Hello, everyone. I've got 10:31 actually on my phone, so I'm a minute late. Sorry about that. I want to thank everybody for attending. There is a Q&A box, so if you have questions, please use that. We are going to have our presentation on just the slides today with no video. That way the slides are as big as possible on your screen. Again, thank you for attending. We're going to speak about the Corporate Transparency Act today and the new reporting requirements that are implemented related to your companies and the beneficial owners of those companies. We've got a couple bosses planned for the future. Date has not been set yet, but a couple potential topics include revisiting the Tax Cuts and Jobs Act from back in 2017. There are several provisions in that piece of legislation that are expiring over the next few years. So I think we're going to review those expiring provisions. As some of you may know, the House just passed the Tax Relief for American Families and Workers Act last night, and that piece of legislation is headed to the Senate. President Biden has said he will sign it if it hits his desk. A few of the provisions in that act, always subject to change. It's only passed the House, so the Senate may have modifications. Few of the provisions are increasing the child tax credit, reinstating bonus depreciation retroactively, allowing those companies that have research and development activities to deduct associated expenses retroactively. And the act also eliminates the employee retention credit effective January 31st. That's the date right now. We'll see if that holds or if the legislation passes once it hits the Senate. All right, my name is Trae Lorts. I'm a CPA in our Jefferson City office. Laura Cutler will also be presenting today. She's a CPA practicing in our Columbia office. And Caroline Boeger here in Jefferson City with me, another CPA in our tax department, will also be presenting. We all deal with the tax issues affecting our business clients on a daily basis and interact with a lot of you very frequently. And we believe today's topic impacts most of your business entities, if not all. So the Corporate Transparency Act on slide 2, it was enacted into law in 2021 as part of a defense piece of legislation. As I said, it creates a new reporting requirement for beneficial ownership interests in companies. I'm going to refer to that as BOI. And the law was put in place to try to combat money laundering and other illegal activity. The Financial Crimes Enforcement Network, known as FinCEN, is a U.S. bureau under the U.S. Department of Treasury. And pursuant to the Corporate Transparency Act, FinCEN is who is in charge of this new legislation. They are in charge of the rulemaking and regulatory part of it, collecting the reports, safeguarding the database of information, and then determining who will be able to use the information. FinCEN stated in one of their notices that the Corporate Transparency Act establishes a database of beneficial ownership information that will be highly useful in combating illicit finance and the abuse of shell and front companies by criminals, corrupt officials, and other bad actors. As a result of the legislation, many small businesses will now have to comply with this rule. So the easiest way to learn about this new reporting requirement is to talk about the key terms included in the act. You'll notice our presentation is organized in this order. I'm going to talk about reporting companies, and then Laura and Caroline will talk about the remainder of these definitions. So reporting companies are basically just the companies that have to file this new BOI report. The act also talks about exempt entities. Those are the companies that meet one of the 23 exemptions from filing, and they don't have to file. So the act divides companies between those that have to file and those that don't. The primary information reported is information about the beneficial owners. So it gets down to the individuals. whether it's indirect ownership or direct ownership, the individuals that own more than 25% of a company, or they have some other form of substantial control over the company. Another part of the reporting is the company applicants for this year, beginning in 2024. And company applicants are the individuals that are in charge of filing and creating new entities, and they also have to be disclosed in addition to beneficial owners. I believe Caroline's going to talk to us about a FinCEN identifier as well. The FinCEN identifier is a unique number that companies and beneficial owners, well, companies and individuals can request from FinCEN, and then they can merely report that number on these BOI reports rather than their personal information being submitted with the reports. Okay, on slide 5, is your company impacted? So what is a reporting company? Reporting companies are defined by the Act as corporations, limited liability companies, and any other entity that's created by filing a document with the Secretary of State, an Indian tribe, or some similar U.S. government body. One thing to note here is it does include LLCs that are considered disregarded entities. Some LLCs do not file a tax return on an annual basis. However, they are still a legal entity, and they are subject to these reporting requirements. Okay, FinCEN has published a guide called the Small Entity Compliance Guide. That guide has a lot of helpful charts, a lot of checklists in it that help you determine if you're a reporting company, who the beneficial owners are, and so forth. This first example identifies who the reporting companies will be. You'll see that we have foreign companies can also be subject to this, as well as U.S. companies. Our presentation is going to primarily deal with, well, our presentation will deal with domestic entities. But if a foreign company registers to do business in a state with the Secretary of State or some similar governing body, they are also subject to these rules. So domestic companies, just to go through it again, if you're a corporation, if you're an LLC, or if you've registered with the Secretary of State or some similar governmental body, you may be a domestic reporting company. You have to make that determination. Okay, now the exempt entities. Those companies that are exempt will fall into one of these 23 categories. If you meet one of these exemptions, you will not have to file a BOI report. So that's good news. You're going to notice a lot of these are similar type entities, and they tend to be heavily regulated entities. Banks, credit unions, and similar entities are heavily regulated. Securities exchanges, brokers, trading companies, those are all regulated by the SEC. And insurance companies, insurance producers, there's usually a State Department of Insurance that heavily regulates those individuals. So there are exceptions here. Later in our presentation, we're going to go through a couple of the checklists for a couple of these companies. So behind each one of these exceptions, there is a checklist that has requirements. So it's important not just to take the description of the company at face value. You have to dig down into requirements to see if you're really exempt. We're going to talk about a couple of the broader exemptions, number 21 and number 23. The large operating companies and inactive entities. So first, large operating entities. So you'll note there's a relatively low bar for this. If your company has 20 full-time employees and you reported over $5 million of revenue on last year's tax return, and both of those things are United States source, and you have a physical presence in the U.S., then you are a large operating entity, and you do not have to file this BOI report. Full-time employee is defined as working more than 30 hours a week. One thing to note here, though, is if you meet this entity, you're not necessarily over the bar. I mean, you have a lot of large operating entities some of my clients will have a leasing company setting off to the side that owns, for example, vehicles or heavy equipment. And then there's a leasing relationship between the operating and that equipment company. We do this to segregate liability and protect assets of the companies. In that case, that leasing company probably does not have 20 full-time employees. So the leasing company itself is not going to meet the exemption, even though the operating company does. Another simple example is real estate LLCs. A lot of you will own your own real estate, and you're going to park that in an LLC outside the company to protect that asset from liability. That real estate LLC probably does not have 20 employees and likely does not have more than $5 million of revenue. So that real estate LLC may need to file these reports as well. So the inactive entities on the other side of the spectrum on slide 9, inactive entities are defined as those that were in existence prior to 2020, not engaged in any active business. They do not hold any assets of any type. They're not owned by a foreign person. They have not had a change in ownership in the last 12 months. And more than $1,000 has not moved in or out of these companies. So one kind of hiccup here is the company had to be in existence prior to 2020. I've got several what I'm going to call shell companies of clients of mine right now that they've created in the last year or so. They just haven't started using them yet. So even though that company is technically inactive, it's not going to be considered an active entity because it was not created prior to January 1 of 2020. Another problem here is I've got clients that will have LLCs that have stopped their business, but for whatever reason, they've left the LLC open and maybe there's $100 in a checking account. In that example, that LLC does hold assets, that $100 in a checking account. So that company's not going to be exempt. So the two big exemptions that we talked about, the large companies and the inactive entities. Okay, what do these reports do? If you're subject to reporting and you have to file the reports, any company in existence before January 1 of 2024 will need to file a report this year. You've got all year to file your report. If you created a company after January 1st, 24, you've only has 90 days to file your initial BOI report. And then next year, companies created after January 1, 25 will only have 30 days. So the time frame starts, these 90 and 30-day periods start when there is public notice that that company exists. So in Missouri, you file with the Secretary of State. Secretary of State issues certificates to both corporations and LLCs. There's a date on that certificate, and it's typically made public on the Secretary of State's website on that same day. So here in Missouri, we're just going to start these 90 and 30 days from the date on the certificate from the Secretary of State showing your business entity. Okay, on the next slide, good news here. You only have to file your report once. There's only one report required, and it's not required annually, but you do have to file updated reports. So there are instances where information changes and you have to file an updated or corrected report. On slide 12, we'll see that both of those reports are due within 30 days of something changing on the report, or you recognize that you maybe filed some incorrect information. And then some of the examples are listed on slide 13. Some of those examples of when a corrected report may be required is if an address changes. Let's say the reporting company's address changes, or an address of one of the beneficial owners change. That's going to be a change that has to be reported. Also, if there's a new owner, a new beneficial owner, that part of the company or all the company was sold, that's going to require an updated report. I think we're on slide 13 right now. Caroline, I think, is going to talk about exemptions from the beneficial owner information. And one of those exemptions is a minor child. So at the time, if you've left a minor child's information off of a BOI report, then at the time that child reaches the age of majority, they're going to have to file the company will have to file an updated report. All right, so that's the overview of reporting companies and dates. I'm going to hand it off to Laura now, and she's going to talk about beneficial owners.
Thanks, Trae. So the information we've gone through so far, determining if your entity is a reporting company and what filing dates we need to be aware of if you are a reporting company. We'll assume now that we've determined that a report needs to be filed. So what information is going to go into that report? First, the ruling requires reporting companies to report certain information about their beneficial owners. Beneficial owners are defined as persons, individuals, not entities, who either own 25% or more directly or indirectly of the reporting company's ownership interests, or if they exercise substantial control over the reporting company. We'll go over each of the criteria a little bit more in depth, but a couple of general comments first. Note that it's one or the other. It does not need to be both to require you to be to require an individual to be a beneficial owner. Although a beneficial owner can and many times will qualify based on both criteria. In the report, companies are not required to report the reason, i.e., like whether it's ownership or substantial control, that is qualifying them as a beneficial owner. So you don't have to report that you are an owner, just that you're like an owner of 25% or more, but just that you're a beneficial owner. And there's no limit to the number of beneficial owners to report. But all reporting companies are required to report at least one beneficial owner. And we'll see how that differs from company applicants a little later on. So we're going to start with discussing what qualifies an individual to have substantial control. An individual exercises substantial control if they fall into one of four categories. First, senior officers. A senior officer is an individual acting in the capacity of a president, CFO, CEO, COO, likely the whole C-suite, could be general counsel, or anyone else performing similar functions to those in these roles. So note that you don't necessarily have to have that title, but if you are performing a function of someone that would have that title, then you would be a beneficial owner. Second, if an individual has the authority to appoint or remove certain officers or a majority of the directors, they also are likely a beneficial owner. And the last two could really run the gamut of who would be included. As an important decision maker, this would include someone making or influencing significant or important decisions for the company's business, finance, or structure. Examples of this could include saying yay or nay to certain business lines or a geographic focus, direction of financial assets. Are they approving the operating budget? Did they structure a reorganization or a merger? Or do they have the authority to do those things? So even if they haven't done them, but they have the authority to do so, they also would be exercising substantial control. And in the reporting guide, the chart on this actually lists the fourth category as, quote, the catch-all. So they're cognizant that businesses are being run in new and unique ways, and certain control, although outside of the traditional indicators of control, could still be substantial control. So those last two kind of really spread out what that substantial control could look like to incorporate potentially a lot of individuals. So before discussing the chart on this slide, recall that the 25% ownership interest is either direct or indirect ownership. And I want to also note that these interests could be capital or profit interests, equity, stock or voting rights, certain convertible interests or options. So in this example, the reporting company shown at the top is directly owned by two equal owners, but these direct owners are entities and not individuals. So they cannot be the beneficial owners of this reporting company. So we go down to the next level as we analyze which of the individuals A through E of the owner, ultimate owners, indirect owners of the reporting company. Let's first look at individuals D and E. D and E indirectly own 12.5% of the reporting company. So they are not indicated as having substantial control here and thus are not beneficial owners because they fall underneath that 25% threshold. In comparison, we look over at individual B, they own indirectly 35% of the reporting company. By ownership criteria alone, owner B is then considered a beneficial owner. Individual A owns a combined 27.5% through both company Y and Z. So if we look at company Y, individual A owns 30% there, and then 50%, and then over in company Z, they own 25%. So we work through that math and we get to a 27.5% number. So individual A is a beneficial owner by just the stock ownership alone, but is also the CFO of the company. So they, both for substantial control and ownership, are going to be beneficial owners. If we look at individual C, like individuals D and E, he only owns 12.5% of the reporting company, but is the CEO and the president. So through substantial control, C is then a beneficial owner. Individual B owns 35%, and so is above that 25% threshold and is a beneficial owner. And we look up at the top and we're reviewing individual F. So we mentioned that has an influencing role on the board of directors, so thus exercises substantial control as a beneficial owner. I'd like to note here that not all members of the board of directors are necessarily beneficial owners, but some may be depending on what level of involvement they have with the board. So like the reporting companies, there were exceptions. So there are also some exceptions for beneficial owners. And so these are the 5 exceptions to the beneficial owner. If a minor child is determined to be a beneficial owner, you can opt to report a parent or legal guardian's information instead of the minor child. Again, this is an option, but it is not required. Nominees, intermediaries, custodians, or agents are not beneficial owners. So those individuals merely acting on behalf of another who is considered a beneficial owner, they themselves are not, and they would report the actual beneficial owner's information. Being an employee doesn't inherently make you a beneficial owner. Employees are typically subject to the will and control of the employer. So as an employee, you would only be a beneficial owner if you were holding those C-suite titles or otherwise exercising substantial control. As an inheritor, you would only have a future interest in a reporting company and would not currently be considered a beneficial owner. They would only be considered a beneficial owner if and when the interest was passed to them. So at the time, the reporting company, at that time, when they did inherit that interest, at that time, they would have to file an updated report. As Trae mentioned, that would have a change in the beneficial owner. And creditors of a company, although entitled to payment from the company, are not considered beneficial owners. So next up, company applicants. Reporting companies created before January 1st of this year do not need to report their company applicants. So if this entity was in existence prior to January 1, company applicant reporting is not required. Company applicant information will only need to be disclosed for reporting companies that were created on or after January 20 of this year. So new entities created this year and this year forward will need to report company applicants. The company applicants can fall into two categories, either the direct filer or an individual who directs or controls this filing action. A direct filer would have actually physically or electronically filed the document with the Secretary of State or that similar office. Every reporting company required to report company applicants will have a direct filer as one of their company applicants. In some instances, the direct filer will be the same person directing the filing action, but that will not always be the case. So to determine who is primarily responsible for directing or controlling the filing of the document, you'll want to consider who's responsible for making the decisions about the filing of the document, such as how is the filing being managed, what content the document includes, and when and where that filing actually occurs. So, and there will only be a maximum of 2 company applicants. So you will have maybe one, if it's just the direct filer that is doing all of that and is primarily responsible for the filing also, or you may have 2, the direct filer and the one that's responsible for directing that action. So next we'll review the information that reporting companies will need to report about themselves and their beneficial owners and company applicants. So a reporting company will be required to report its legal name, any trade names or DBAs, the current street address of its principal place of business, and it must be a physical address, so it cannot be a PO box. Its jurisdiction, i.e. state of formation or registration. And so for most of us on this call, that would be the state of Missouri. It will be required to report its taxpayer identification number. So this could be an EIN or it could be a social security number. A social security number would need to be reported for those LLCs that Trae mentioned earlier that do not have an EIN associated with them, as some legal entities, if they don't have payroll or otherwise have any reporting with the federal government, are not required to have a federal EIN. And the type of filing will need to be reported. If it's an initial report, a report correcting an error, or a report updating a piece of identifying information for itself or for a beneficial owner. The information needed on beneficial owners and company applicants is not extensive, but it is personal. Fortunately, they haven't required social security numbers for our beneficial owners or applicants, but that's kind of where it stopped on the personal level. So for each individual beneficial owner or company applicant, the information reported is the same. That information is their legal name, their date of birth, a residential street address, not a PO box, and then an identifying number from an acceptable identification document from the state or jurisdiction that issued the identification document, and then also an image of that document. So what these documents are, it'll be, so acceptable ID documents include driver's license, some other form of ID issued by a state or local government that is used to identify that individual, or a passport. So note that all forms of IDs must be up to date. Expired identifications or passports are not accepted. If it's a foreign individual, it must be a foreign passport. They won't allow any other IDs that have been issued by other countries or in the states of those countries. So now we provided all of this information and we really want to know who's going to be using it. So they've indicated that it will be the U.S. Department of the Treasury, U.S. federal agencies engaged with national security, intelligence, and law enforcement, which this could potentially be FBI, CIA, military branches, etc. State, local, and tribal enforcement agencies, financial institutions with customer consent, federal and state regulators assessing financial institutions, and qualifying foreign law enforcement agencies and authorities. So quite a few agencies will have access. We don't necessarily know yet how they will be using this information, so that is kind of yet to be determined. But given the personal nature of the information they have, that we will have provided, or individuals will be providing, they have provided some small veils to help protect that data as these reports are being completed. So Caroline is going to fill us in on what that layer of protection might look like.
Thank you, Laura. So as we just heard, there's a lot of information being requested about reporting companies, their beneficial owners, and company applicants. And this can be made even more complicated and inconvenient for those with ownership interest in multiple companies or those who are part of tiered ownership structures. And this is kind of where those FinCEN identifiers come in. So a FinCEN identifier is a unique ID number that FinCEN issues to an individual or reporting company upon request once they've provided certain information to FinCEN. Reporting companies can then report these identifiers in its beneficial owner information report instead of all of the pieces of personal information for beneficial owners and company applicants that Laura just went over with us. FinCEN identifiers are not required, but they can be a time saver, especially for reporting companies, and they can eliminate the need for individual beneficial owners and company applicants to share their personal information with reporting companies. And just a note that only one FinCEN identifier is allowed per person or per reporting company. Next, I would kind of like to go into a little bit more detail about the FinCEN identifiers specifically for individuals on slide 24. So for an individual to obtain a FinCEN identifier, they need to submit the following pieces of information to FinCEN, and that's their name, date of birth, their residential street address, and a unique ID number from an acceptable identification document, the state or jurisdiction from which it was issued, and an image of the identification document. And this is that driver's license, passport, or other ID document that Laura just referenced. These items an individual is reporting to FinCEN to obtain the identifier are the same pieces of information they would disclose to a reporting company as a beneficial owner or company applicant. So someone requesting an identifier isn't disclosing any more information than someone who doesn't request an identifier. Once the identifier is obtained by the individual, the reporting company can report that ID number in place of all the personal information about the individual on those beneficial owner reports. They would just submit their name and the FinCEN identifier only. If an individual does decide to obtain a FinCEN identifier, they can apply online for it at FinCEN's website. Once an individual submits their application, they should immediately receive the identifier. And I will note that for individuals, the FinCEN identifier application is a separate form from the beneficial owner filing report. So it's just kind of one more step in that process. It's a separate form. If any information an individual reported to FinCEN to obtain their identifier changes or is later discovered to be incorrect, it's the individual's responsibility to then update their reported identifier information with FinCEN within 30 days of the change. It's not the reporting company's responsibility to file an updated beneficial owner report if the individual has a FinCEN identifier. So we could see a lot of reporting companies encouraging their beneficial owners to obtain FinCEN identifiers because it shifts the responsibility from the reporting company to the individual to update that information. Next, on the flip side of that, I want to dive into FinCEN identifiers for the reporting companies. It's a little different because there's no separate application for a reporting company to request a FinCEN identifier. They can simply just check a box on that beneficial owner information reporting form, just saying that they would like to receive one, and then they will receive one later. So it's a little easier than the individual to check box on the same form. The same rules apply as individuals for whenever there's changes or corrections made to a reporting company's information who's applied for a FinCEN identifier. They have 30 days within the change to update and correct the information reported to FinCEN. So we've already talked a little bit about why we might want a FinCEN identifier, but I'd like to kind of go through a few more reasons. If you're a beneficial owner of multiple reporting companies, that could be incredibly beneficial for you to obtain a FinCEN identifier. If you're an individual and you decide to get an identifier, you're submitting your personal information to FinCEN one time to get the identifier. And you can use that on any reporting company's beneficial owner report. If an individual doesn't obtain a FinCEN identifier, then that means they have to disclose their personal information to every single reporting company they're a beneficial owner or company applicant of. So the identifier is really just a time saver in these instances. Another reason is protection of an individual's personal information. The identifier eliminates the need for individuals to share their personal information with the reporting companies multiple times. They would just be submitting their personal information to FinCEN only. If you're a company applicant for multiple reporting companies, specifically, we're going to kind of use attorneys and paralegals as an example here, since they're ones who would aid in submitting a lot of documents to the Secretary of State and would be considered company applicants for so many reporting companies. It would save them a lot of time and just be much more secure for their information if they can just send the reporting companies their FinCEN identifiers instead of constantly having to disclose their personal information over and over again to the various reporting companies. Another reason, if you're a guardian of a minor child who is a beneficial owner of a reporting company, Laura touched on this a little earlier, but if a minor child is a beneficial owner, they can qualify for an exception from reporting their beneficial owner information as long as a parent or legal guardian reports their information instead. So while that child is still minor, if the parent or guardian decides to get a FinCEN identifier, it kind of saves them from having to submit their own personal information to a reporting company that they're not even a beneficial owner of. And finally, identifiers help streamline the reporting process. It's quicker for the reporting companies to disclose a beneficial owner's name and FinCEN identifier than to gather and report all of that personal information required for every single owner and company applicant. I know at Williams Keepers, we are planning to default to getting a FinCEN identifier for reporting companies that we're submitting the reports for. We're planning on just making that our default to select the box to obtain a FinCEN identifier while we're doing the application. So kind of one of our last little topics here is talking about penalties. A person who willfully violates the beneficial owner reporting requirements could be subject to civil penalties of up to $500 per day that the violation continues. And I'd like to note that there's no cap here in those rules. So, $500 a day can add up incredibly quickly. That person could also be subject to criminal penalties of up to 2 years in prison and $10,000 in fines. Individuals and entities can be held liable for willful violations. It's not just one or the other. There can be multiple violators in kind of a single instance. And on the next slide, I've listed some examples of these willful violations. For example, willfully failing to file the report at all, willfully providing false information on the report, willfully failing to update or correct previously filed information, willfully providing false information to someone who is filing the report. And the last one is something I kind of want to draw attention to, is willfully causing a reporting company's failure to submit complete or updated information. It's not only someone willfully just failing to file or send in correct information, but if someone is intentionally willfully causing the reporting company to fail to comply, this is considered a willful violation. And we aren't here to define what FinCEN meant by the term willful, only they know that, but we did just want to draw attention to the fact that the rules do specifically state that all of these penalties are in regards to willful violations. However, there is a safe harbor from these penalties. If you believe a report filed with FinCEN is incorrect and you submit a report to correct the information within 90 days of the deadline of the original report, then there is a safe harbor from these penalties. And remember, these are for willful violations. If you can file these reports electronically the same way that the original reports were submitted, and we'll show an example of what the form looks like, but it does ask on the form the type of form, and you have to choose initial or updated or corrected. So you would just want to make sure that you're choosing the right form, which would be corrected. So just something to look out for there. But there are safe harbors from these penalties as long as you were filing within the 90-day period. So kind of to start heading into wrapping up just a little bit, I just want to walk through a few helpful hints. Beneficial owners of multiple entities may want to consider obtaining a FinCEN identifier. As we've already talked about, it can really streamline the process and help to protect personal information. FinCEN identifiers are available for entities and individuals, and it can be beneficial for both of them. As Laura said, PO boxes are not allowed to be reported in the address information section of these reports. It has to be a physical street address. And make sure you're being diligent of any scammers trying to trick you into submitting any personal information somewhere that's not the regulated FinCEN website. I know I've already seen a couple of phony flyers out there, and FinCEN on their websites kind of put out an alert that they are aware of some phony flyers and some bad actors kind of floating around. So just be very diligent of what you see. So lastly, we have a resource page here. And so I kind of want to direct you guys to some of the resources that we've used, not only in our research, but some that we have written ourselves. So I'm going to take control of the screen here. And so this is from the resource page here. I clicked on that first link for the homepage, and this is the FinCEN webpage specifically for the beneficial owner information. One really helpful resource is the frequently asked questions page right down here. So the FAQ page is broken down by topic. So there are questions related to reporting companies, beneficial owners, the reporting process, due dates, FinCEN identifiers, a lot of the topics that we've covered today. These are all kind of grouped together in sections. And something really handy about the FAQ page is that once you kind of spot the question that you would like an answer to, you can click on it and you'll be jumped to that section that provides the answer. So for example, right here, if I wanted to see when do I have to file my initial report, if I select it, it jumps me right down to the section where it gives the answer. So I don't have to scroll down and try to find it. And then lastly, on the FAQs up at the top here, if you would like just a PDF of all the questions and answers instead of this web page, you can click on the PDF version and it is available. So that way, if you want to share this and send it between people, or you just want a full list of all the questions and answers together, that is available. I'm going to go right back to that beneficial owner homepage right here. Something else we wanted to touch on was the small entity compliance guide. So up here in the small business resource section and the small entity compliance guide. This guide was published by FinCEN, and it really does a good job of explaining a lot of the beneficial owner report concepts. The table of contents right here works incredibly similar to the FAQ section, where if you see a topic that you'd like to jump to, you can just click on it instead of scrolling. For example, if I wanted to see more information about the exempt entities, right here, I would just click on it and it jumps me down to that page. And this is the same chart that we had in our presentation. However, the small compliance guide does provide more details on the exempt entities. So you see here, there's exempt number 1 through 23. If you scroll down and make sure you're looking at the correct number, it goes into a little bit more detail about each of these exemptions and provides a corresponding checklist where you can kind of review these and help evaluate whether your company falls under any of these exemptions. And I would like to note, we have this nice list up here of exempt entities, but that doesn't mean just because your company is on this list that you're home free. The checklists are really going to be a helpful tool in determining if a company is exempt or not. For example, I'll scroll down to the large entity exemption, which we kind of have gone into more detail about. But all of those exemptions are here about the 20 full-time employees, the 5 million in prior year gross receipts, the physical US office. More details are here. So just make sure you are being diligent whenever you're looking at the list. You're not just stopping at finding your name on the list. And then the last thing I wanted to show on the homepage here was just a copy of the actual filing form. I will note that whenever you do try to get a PDF copy of the form online, it acts like it downloads and it acts like you should be able to open it. However, if you don't have the right version of Adobe, then you kind of get this error page, but it still likely has downloaded. It's just kind of a quirk of the FinCEN website and just something we wanted you to be aware of that could happen. The form does come with instructions at the top of, fill it out completely, how to validate and finalize and save and submit it. And so whenever you scroll through the form, it's kind of in the same order and has a lot of the things that we talked about today, like the type of filing, the reporting company information, the beneficial owner information, the company applicant information down here. And one really great thing about the PDF form, especially these yellow boxes, is that if you hover over one, it kind of gives you a little bit further instruction where it popped up. See, and I'll pick a better example here. For example, right here, it's asking for a company applicant identifying document type. And if you're on this form and you don't really know what that means, if you hover over it, it gives a little blurb there about the type of document that's acceptable, such as the driver's license, the passport, the other state identifying documents. So it's great that it gives a little bit more detail on what you're asking for without having to go right back into the instructions. And then at the very bottom of the report here, this is the beneficial owner section. This is where you can add the attachment for those driver's license and state ID photos. This is where you can add those. And once you fill out the form, back up here at the top, it will go through having you validate just to make sure the form is complete, finalizing the form, saving it, and then you can upload it directly to FinCEN's website by clicking ready to file. And right now it's not showing that I can file because I haven't completed the report. But once you have all the fields filled in, you can click ready to file and it takes you right back to the website. So, and then from there, that was really what I wanted to show you from the resource page. And then I also just wanted to point out that Williams Keepers also has a website. It's just williamskeepers.com, and we have our own FinCEN section of resources and some articles that we've written and shared with clients. And so we just wanted to point that out to you, that can be an additional resource for you as you need it. And I'm not sure if Trae or Laura have anything else to add. Otherwise, I think we're ready to start taking some questions.
Thanks, Caroline. I think at this point, we are ready to take some questions. We've been keeping up with those as we've gone. I'll try to take the first one. And you asked if we could elaborate on the revocable living trust question regarding whether the beneficiary of the trust is a beneficial owner. If two spouses each own 25% of an LLC via their separate RLTs, but the two beneficiaries are also RLTs with ultimate single beneficiary who is currently a minor, does that minor or parent guardian have to report as a beneficial owner? Okay, there's a couple things going on here. So I think one of the exemptions for beneficial owners that we covered, I hope we covered it, was someone that has an inheritor interest. So if their only interest in an LLC is as an inheritor, and they don't get that interest until someone dies and it passes to that person, the inheritor is not a beneficial owner. However, the active beneficiaries, and I believe the active trustees, are going to be beneficial owners. The second thing you ask is about minor children. So if you have a minor child that is determined to be a beneficial owner in some fashion, through any ownership, whether through a trust or through just themselves as an individual, or through a tiered ownership entity through another LLC. If a minor child is a beneficial owner, the guardians or parents can make the election to not report the minor child, but in its place, the guardian or parent has to be reported. And then at the time that minor child becomes a, at the time that minor child becomes, meets the age of majority in the state, whichever state they live in, that's when the report has to be updated with the minor child's information. Long answer. Laura, you want to take Wendy or Ryan's questions? Or Caroline, either
Sure.
one, you're both muted.
Sure, yeah, I can take it. Wendy, so the question is, do you send in a change report for when a company closes down? And the answer is yes. When there is a change in the status of the reporting company to where either it is where it is no longer a reporting company. So if it were to close down or ultimately meet one of the 23 exceptions, there is a filing required at that time.
And I can answer Ryan's question, and Trae and Laura, feel free to jump in. Is there any obligation or liability for a bank to verify the accuracy of a BOI filing? I think where you want to be careful is and I know it's something we've got to be careful for also, is making sure we're not doing the unauthorized practice of law, where I think if you're reviewing the information, names, addresses, and just taking a look at it, I think that's all right, but you just want to be careful that you're not kind of the sole advisor of who's a beneficial owner, who's a company applicant. Those determinations really do need to be made by the company. So you just want to be a little careful that you're not trying to legally advise them when it comes to that.
Yeah, I'll take Alicia's question. I think there's a little bit of a distinction for not-for-profits. There's been a couple questions. So not-for-profits are created by, or not-for-profits can be created by a filing with the Missouri Secretary of State. But then that not-for-profit does not necessarily have to apply for tax exempt status with the Internal Revenue Service. So the exemption from filing has to do with tax exempt entities. So those are entities that have filed with the IRS and have been approved by the IRS for tax exempt status. And this is kind of a general answer. And generally 501Cs as well as 527 political organizations are going to meet the exemption. But there are a lot of details to those. So if you have a not-for-profit and you have an exemption, it's probably worth it looking at the details. Nolan Greer. Okay, so Nolan, for a company with multiple wholly owned subsidiaries, does this form need to be filed for each company or for the parent? The answer is all of those companies are subject to these rules. The parent may meet a general exemption. And at this time, I've reviewed some of the questions and answers that FinCEN has put out and reviewed other guidance from FinCEN. There appears to be some conflicting information. If you look at the 23 exceptions, I believe one of those is subsidiaries of exempt entities. However, if you read the frequently asked questions, there is indication in there, and if you look at the form, there's a way for subsidiaries of exempt entities to file a BOI report, and there's a box to check that says that they're owned by an exempt entity. So I don't think we know for sure yet if the subsidiaries have to file these reports, but in general, any legal entity, subsidiary or not, are subject to these new this new Corporate Transparency Act. Sorry, we can take this offline if you want to go a little deeper. All right. I don't see anybody raising their hand and no more questions in the Q&A. One more. Anybody else want to turn? Caroline, Laura?
I can take it. Warren's question sounds like providing this new ID may develop into something financial institutions, banks, etc., will require us to submit on a regular basis. For the purposes of this report, you only need to submit the ID one time, unless there is a change to it, unless you update your license or anything like that, then you need to submit. In terms of any other reason that, financial institutions and banks might start requiring us to submit more information, that could happen. I'm not necessarily sure we can speak to it here, but it is interesting.
I can take Robin's question. Robin asked, how do you get the FinCEN ID before filing the report? And if I could hold on 1 second, I can navigate to it as we go through. So on the FinCEN website, it is in this file section. So the FinCEN BOI, or FinCEN.gov BOI, create a FinCEN ID in this file section right here. And it will go through the process of putting in your information, and it will provide you with that identifier.
And something I will note is that whenever if you file these reports online, you obviously have to submit an email address for the submission, and you do get an email correspondence from FinCEN saying that they've received your report. So you will receive something that says that they have received it as kind of proof.
Well, is that when you apply for a FinCEN ID, Caroline, or some other, or the report itself?
I have not myself applied for a FinCEN ID for anyone yet. But I imagine it would be the same. I imagine it would be extremely similar to filing the report, where you also would get an email receipt for it. But I have not tried it myself, so please take that with a grain of salt. But
Okay.
I know with the actual reports, that's how it's done. I would imagine it's done the same way.
Yeah, when you file the BOI report, and Pete just answered in the Q&A, you received one for both. But when you file this BOI report, and also when you file for a BOI, a FinCEN identifier, I'm viewing that as a permanent record of the corporation. You're going to get a transcript as a result of these filings, and you'll want to keep that transcript kind of as a permanent record as as you do your incorporation or your LLC organization paperwork. And then unfortunately monitor that occasionally if there's ever a change, so you're filing corrected reports on time. All right, if there's no questions that come in the next minute or two, I want to thank everyone for hopping on today and joining the presentation. And please look out for the notices we're going to send out for those upcoming boss seminars. I know Jeremy's excited to get back on the mic as well. So thank you all again. One more. We'll take with us one more question, then we'll hop off. Okay, so answering Robin's question, we do plan at Williams Keepers. We are in the process of putting a system together where we're going to file these on our clients' behalves. We will not do any filing without your request, so we will talk to you first, and more information is coming about that. All right, thank you, everybody. Enjoy the rest of your day. Goodbye.